everybody, welcome back to the Starved Rock Murders. I'm your host, Andy Hale. Got two guests with me today. My colleague, Sally Cohen, who you've heard from before, and we've got a first-timer, Johanne Karizamimba, who also works with Sally and I at Hale Law. Welcome, Johanne.
Thank you. Thank you for the welcome. Happy to be here.
So what I want to do today is have each of us take turns and pick out a piece of evidence that you were really struck by the way it got handled, either by the Will County State's Attorney's Office and or Judge Jans. And that was the assignment I gave to both Sally and Johanne, and I've got one myself. So what I'd like to do is go through that evidence and talk about that. Before we do that, though, I want to tell everybody there's a big update. We filed this petition for posthumous clemency. We filed it with the Illinois Prisoner Review Board. It's going to be heard in October. But people have asked me over the years, how can I help? How can I get involved? Here's how you can help. We've got a change.org petition. We're seeking online support. You can just add your signature to our petition. We've got over 1,000 people already. There's a link in the description of this podcast below. If you've been with us, if you're new to us, please check it out. We'd love your support. Change.org, check out our petition. All right, let's get into it. Sally, I'm going to start with you. What piece of evidence or issue did you select?
So I selected the evidence of Deputy Bill Dummett's misconduct for several reasons, because I think that the court's response to it was really ridiculous and misguided. So our listeners may remember that the evidence from the original trial was that Dummett had threatened Chester with the death penalty, saying that he would ride the Thunderbolts if he didn't confess. So then he lied about having ever said that on the stand, and he was impeached by one of the prosecutors. So by a very reliable, very good impeachment. So Dummett definitely said that, and he perjured himself on the stand. That's in the trial record. Everybody knows that. Chester also had testified that Dummett had walked him through crime scene photos to induce his confession. Of course, Dummett denied that on the stand. Okay, this was not known at the time of trial, but it would become known later on that this was a pattern of Dummett's. So in a 1980 case, so obviously it's 20 years later, Stephen Broadus was charged with murder, and he insisted that Dummett had shown him autopsy photos. Dummett denied taking the photos, using them against him, or having them in his possession. But when it became known that Dummett was the one that took the photos, the judge ordered that Dummett's office be searched. And lo and behold, they find the photos in Dummett's desk. So lying again. Okay, then in 1970, going backwards, so 10 years before that, in the middle of between 1960 and 1980, a man named Robert Harris was charged with participating in a large robbery, for which he was facing potential term of 60 years. And he was charged on the basis of a statement of this guy, whose last name is Stevens. Long story short, Harris's attorney went and found Stevens, who said that Bill Dummett, among others, had concocted the statement and basically made him sign it in exchange for a lighter sentence on an unrelated charge for him. Okay, so, of course, our judge did not let any of that information in at our third stage hearing. However, we were able to introduce some evidence against Dummett and against his credibility, which was that we had a witness, Randy Reynolds, who testified at the third stage hearing that he attended Dummett's retirement party in 1982 and heard Dummett say, "I knew Chester Weger was innocent, but I got that son of a bitch to confess." So that was in there. We also had, the documents, the handwritten notes of Harlan Warren, in which there's a line there that they're talking about that plane that was flying overhead, and the note next to it says, "Wayne said deputy made this up." I think it's fair to assume, Wayne is Wayne Hess, and that Deputy Dummett is the deputy being referenced there. So I know I've been rambling here for a while, but let me read you, and this is going to be a little bit lengthy too, how the court treated Dummett's credibility here. Yeah. And this is when he's discussing Randy Reynolds' testimony at the third stage hearing about having overheard Dummett say that he knew Chester was innocent.
And just to be clear, what you're going to read is from Judge Jans's opinion denying our third stage post-conviction petition.
Yes.
Okay.
And I'm going to skip a little bit about it, so I'll jump to the meat of it, okay? The court accepts that Reynolds attended the retirement party, but the court finds that the surprisingly detailed comment about what Dummett said, namely that Chester Uyghur was innocent and I got him to admit it, is not believable, especially since he could remember few details about who was present for the statement. He admitted that the Starbrook murders did not mean much to him back then, and it was not until he had a conversation with a family member interested in investigating the case 40 years later that he decided to say anything about it. The court also finds this statement is not credible based on the prior trial court record. In pretrial hearings, Judge Hoffman concluded that defendant's confessions were voluntary and admissible. At trial, the defendant denied that his confessions were true and testified that he was told what to say by Dummett, who had done the investigation and was familiar with the evidence. However, part of his confession included his statement that a red and white airplane was flying over the area at the time of the murders. This is something that Dummett could not know because there was no evidence of the plane at the scene. This fact could only be known by someone who was there. Any claim by defendant that Dummett told him this information would require this court to conclude that Dummett was so clever and intent on framing the defendant that he investigated and created corroboration that would not be present at the scene. Alternatively, it would require this court to conclude, as argued by the defendant in his original trial, that Dummett was able to convince the two witnesses who testified about the plane to commit perjury to ensure defendant's conviction. The jury did not accept this theory, and this court does not accept it either.
Big sigh from me. So go ahead. What do you make of all that?
One other thing to mention that the court does not mention here is that it is uncontroverted that Dummett received a reward for having broken the case that's equivalent to $60,000 in today's terms. So I mean, that's not nothing. It certainly is a motivation to lie, and it's completely unconscionable in today's legal world. I mean, that alone would get the confession tossed. But to me, it's very circular reasoning. This evidence was not available at the scene. You have a note that says deputy made this up. Chester's telling you that his confession includes what Dummett told him. So yeah, it doesn't exist at the scene because Dummett made it up and then went back and created the corroborating evidence. It's all very clear to see this. And it, to me, takes willful blindness not to read it the way that we do. And that is why I think that this treatment of this evidence is egregious, especially given that other courts, the two cases that I mentioned, one of them was resulted in an acquittal of the defendant, and the other one, the charges were dropped. So other people know that Dummett is corrupt, but the jury who didn't hear all this evidence believed him.
You said so much there that's so powerful to me. And so let me make a few comments, and then Johanne, gather your thoughts, and I'll let you chime in here. Willful blindness is a great term. I wrote that in my notes. Willful blindness, that is a great way to put it. There's so many things I want to say about this. But the first is, so you've got somebody saying I was coerced to confess, right? So you always start with, well, who's the person that you allege coerced it? And, if the state would have come back and said, well, it's Officer, Andy Griffith from Mayberry RFD. This guy's the honest as the day is long. There's no way. Nobody would believe that. Dummett's got this long pattern and practice of misconduct. And if you talk to people that know Dummett or knew Dummett, every person tells you that. That's what everybody tells me. Oh, Dummett. I mean, when I talk to Louis Getch, remember Louis Getch? I went to his house with Chester Uyghur, when after Getch ran into Chester and his nieces at the grocery store. And in our interview, he called him, and he said it like that. He goes, Bad Billy Dummett. Bad Billy Dummett. He's in his 90s. He's still talking like that about Dummett. Mm-hmm. Robert Harris, let me tell you, what we submitted was a deposition. Okay, I met this guy at a VA hospital, and then we took his deposition. He was, I think, in his 80s at the time. He was still hot as a pistol about Dummett framing him for a very, very serious crime. I mean, let's pause there. If you'd have been sitting with me at the table when I was deposing Robert Harris, you would have felt his anger. And there was not 1% chance he was making this up. Why would he at this age? So think about that. If Dummett would do this to people, I mean, did it to Chester Weger, did it to Harris, we're dealing with somebody who is a really, really bad person. And I got one other comment. For the judge to say Dummett would have had two people to commit perjury, I actually think the plane was flying overhead. The whole point is he was a member of the Ottawa Airmen's Club. He had access to those flight logs, and he could see, oh, there's a flight that went over Starved Rock. So I actually think that testimony was likely true. It's just that Chester Weger didn't say it. Chester Weger didn't make that part of his confession. And Dummett's not that smart. Dummett's actually kind of dumb. The plane going overhead would have no impact on somebody in the canyon whose goal is to get out of there. You know, seeing the plane overhead, oh, so now I got to put the bodies into the cave? What's the difference? It doesn't matter. I mean, the whole plane story was ridiculous. And like you say, got impeached at trial by his partner, one of his colleagues. I mean, Dummett works for the LaSalle County Sheriff's Office. Craig Armstrong's the state's attorney. He's in the car with Dummett and Chester. You get impeached on one of the most powerful things. You get impeached on the statement that basically is leading to the false confession later that you're going to ride the Thunderbolt. Oh my God! I just could go on and on about this. Johanne, what are your thoughts on this?
I think kind of just picking up exactly with what you were just finishing up there. It's what really sticks out to me is that this didn't happen in a vacuum. It really did happen after this specific perjured testimony had already come out, that Wayne had directly contradicted him, had shown that he did in fact say ride the Thunderbolt. He had lied about it. And then obviously how that later contributes to the confession itself. I just fail to see how that does not lend credibility to everything that Sally was just articulating here and outlining. How that doesn't just lend credibility to Randy Reynolds' statements and articulations of what Dummett was saying during that retirement party, because you already have evidence in the trial transcript showing that he's already of this kind of specific nature and ilk, you know? So it truly is, I agree. I think this is a perfect example of something that really sticks out to you because it doesn't make sense. So.
And by the way, my issue is going to be Randy Reynolds, so I'm going to talk about that a little more when I go. But Sally, talk just a little bit more about when you say willful blindness. Explain what you mean.
So what I mean by that is that you've got a conclusion that can be drawn from the evidence, and that you've got a different conclusion that you can stretch to find by ignoring all the evidence. And given the choices between those two avenues, our judge took the one that requires you to really, A, not admit this evidence so you don't have to discuss it, and then B, to leap to conclusions that are not supported by the evidence. For instance, when you say, he says, it would require you to believe that Dummett was able to convince two witnesses to commit perjury to ensure the defendant's confession. As you said, they wouldn't have had to commit perjury. The person that would have had to have the intent to lie to the court is Dummett. And Dummett already did lie to the court. So it's not a stretch to suggest that he would have no moral qualms about that. And the other part of this is, through all this misconduct that piles up, you get the sense that Dummett, he undertakes this brazenly, and he's proud of it, which again tracks with what Randy Reynolds heard him say at his retirement party. He's not doing this in secret, and he seems to want to brag about it. So that also lends credibility. In a normal circumstance, if you have Andy Griffith, deputy, and somebody says that they took credit for something so heinous, you might not believe him. Here, everyone believes him, besides the court.
And remind me, why, when I look at this, like you said, this pattern and practice evidence, other than, we know what Craig Armstrong impeached Dummett. It's in the trial record, right? It's in the trial record. But I refresh my memory of how the judge claimed this new pattern and practice evidence that we discovered. And by the way, Donna Kelly, shout out to former Chester Weger lawyer Donna Kelly. She's the one who found the Brodus case and talked to some of these people. How did the judge claim that wasn't new evidence?
So it's my recollection that he barred that evidence because he found that it was only relevant to the constitutional claims that were dismissed. That's my recollection, that evidence about Dummett's credibility was not related to the actual innocence claim.
How can that be, though? I mean, the whole point is Chester's claiming he was coerced to confess,
right,
and his whole case is based on a confession. So Dummett's credibility is front and center, isn't it?
Absolutely. And I think, again, we would have appealed the constitutional rulings too, had we gotten the chance to appeal. It would not have just been the what happened at the third stage hearing. I don't know if our listeners know that, but you cannot appeal stuff in the middle of a case. So you have to wait until it's over, typically, to appeal a ruling. So our constitutional claims got dismissed way earlier, but we couldn't appeal them until the third stage hearing was over. And then we lost our opportunity to do that. But this all, I think, would have also been overturned by an appellate court.
Johanne, anything else to add?
No, not anything immediately. I think you guys have articulated it very well. It really is. It just, again, it's astounding. I think what I'm kind of picking up here as well is that a lot of us actually focused in when we're thinking about the thing that really stuck out to us are the witnesses and how the court actually treated the witnesses. So I just think that's interesting in and of itself. That is something that kind of bridges all of us.
Yeah, and I think it's pretty amazing that, the impeachment here wasn't something minor. The impeachment was probably the most threatening thing Dummett said, which is, if you don't confess, you're going to ride the Thunderbolt. You're going to get the electric chair. And I want to put that in context. So we know that's true because Craig Armstrong said, Dummett said it. So we know it's true. Let me just put this in context. This is in when Chester's coming back from John Reed from the all-day, all-night polygraph in Chicago. There's no evidence. There's nothing linking Chester Weger to the crime. So why is Dummett even writing him so hard? I mean, they're writing this 21-year-old kid so hard. And I think it's incredible that both Will County and the court just basically kind of ignored it and acted like it was no big deal, Sally, anything else on this issue before I turn it over to Johanne?
No, I mean, I could speak for hours about the court's treatment of Randy Reynolds, but I understand you're going to pick up on that.
Well,
so.
I'll pick up on it and then I'll let you jump in, but we can both talk about it because there's a lot to talk about with Randy Reynolds. So Johanne, when you looked over the case, and for all our listeners out there, Johanne, has really gotten involved a lot just the last several months. So although he hasn't been with us as long, he is pretty much up to speed on a lot of the key evidence. It was a big part in helping us prepare the petition for posthumous clemency. So what kind of struck you when you looked over some of this?
Yeah, I think kind of at large of what we've already been discussing is the court's treatment of Chester's exculpatory witnesses in the 2025 proceeding at large. But I think specifically its treatment of the state's own witness, Alice Boehm. I think the court's handling of Ms. Boehm's testimony is truly mind-boggling to me and truly demonstrates that something else, right? Not the law, not logic, not some philosophical conception of justice was motivating the court's ruling and handling the case in its entirety. Because the leaps that the court has to take to justify its discrediting of Ms. Boehm's testimony are illogical and also just pretty astounding in and of themselves. And I've never seen anything like it. And so as I was kind of going back through, just filtering through my thoughts, it was very clear that to discredit her, the court had to do two separate things, right? First, it's those illogical leaps that I had just mentioned. And there were two aspects of that. It was first on the law, right? In the judge's order, he actually specifically identifies her testimony as hearsay. And then just full case stop period right there. Doesn't engage in any analysis or a review of that, because it's very clear that it's a statement against interest, which is an exception to hearsay and would be allowed to actually factor into the court's ruling. That's something that we fully highlighted actually in the brief when, related to that and fully outlining how it is a statement against interest. So it really stuck out to me that he was just instead she just provided some hearsay testimony from Smokey Rona and period, moves on entirely. When any other, kind of decision weighing, measuring of what that testimony is has to go through that analysis process, seeing those standards. And I I'm left to believe that he doesn't actually engage in that standard or that analysis just because the result would be inevitable, that it is in fact a statement against interest. So that was one kind of leap. It was just completely ignoring it on the law. Then the second aspect was on the facts itself, right? Stating that it was that her testimony was not credible because it didn't exactly line with the testimony of Roy Tyson. First, like, it did align in very key details and very pivotal ways with Roy Tyson's testimony, but also the expectation that testimony from two separate witnesses or multiple different witnesses have to line up in every single little detail is unrealistic. It's kind of not heard of. If anything, that's actually a sign of it not being credible, because if the testimony is exactly the same, it means that people potentially have been speaking about it, things of that such. People perceive things in different ways and have their own experiences and stories and relationships with Smokey Rona, so different information would come out. So again, that really stuck out to me. But I think one of the key ways he actually went about going to discredit Ms. Boehm's testimony was just entirely ignoring key considerations and facts related to her, right? And I think it all comes down to the fundamental fact for me that this was a state's witness, right? The defense didn't call her, the state did. The state was the one who independently, without the influence of defense counsel, elicited and developed the narrative around Smokey Rona's responsibility for the murders and mob involvement, completely irrespective of what the defense was saying. And the state independently provided evidence supportive of Chester's innocence with their own witness that was directly in line with the additional evidence that we'd already uncovered and we had already brought on. But not only that, it was that the state's own witness explicitly and repeatedly clarified that Chester was not involved, and that was something that Smokey Rona spoke directly to her about. And obviously the state attempted to hide that fact, right? In that specific regard, in their direct examination, state attempted to characterize Smokey Rona's statement that he committed the murders with friends to include Chester. And then trying to paint a particular picture, literally cutting her testimony off to move on after listing that one line. And then, however, we were able, obviously to quickly reveal that the state was attempting to mislead the court, right? On cross-examination, Ms. Boehm was adamant that Rona clarified that the friend did not include Chester and that he was not involved at all, that he was entirely innocent. And then, taking it again another step forward, defense counsel even pointed to the affidavit that the state had prepared, probably attempted to not actually hide, to not actually bring into the hearing itself, but saying that this wasn't a revelation she was having on the stand, that it had always been her testimony that Rona had explicitly stated that Chester was innocent and was framed. So again, that I think her encapsulating her as an entire witness just really sticks out to me, because to me, this is probably one of the most credible witnesses in the exculpatory witness sphere for Chester's innocence. It's one of the most credible just because it comes from the state themselves. They independently elicit the narrative that we have already built and provided evidence for. Then this is Smokey Rona's actual sister, right? In any other circumstance, that independent fact would lend more credibility to her testimony, right? Given the incentives family members have to not provide incriminating testimony against other family members, but even what she testified to, the growing relationship she had with Smokey Rona near the end of his life, right? That it lends more credibility to it. And even more so, I think what's very interesting and what really sticks out to me from an advocacy perspective is I think it's an absolutely terrible strategic decision on the state's part to even call Ms. Boehm as an affirmative witness on their part, especially given her existing affidavit, right? And that the fact that her testimony closely aligned with the narrative and the evidence that we had already uncovered. And then it was an even worse decision to try to manipulate her testimony, where they just set the stage for an amazing, adding more profundity to the fact that her herself testifies that Chester was innocent. Smokey Rona was adamant on that fact. So all in all, just because of all, I know I've been speaking for a little bit.
Go for it.
But all of that together really makes, and then for the court's ultimate decision, which if you don't mind, I'll just read it out because I was reading the language. It's absolutely insane. When the court evaluates her testimony with the trial testimony, the court concludes it does not support a freestanding claim of actual innocence, is not sufficient for the court to lose confidence in the guilty verdict, and that it is not probable that her testimony would lead to a different result. insane to me. That conclusion literally comes after quite literally 4 sentences of analysis, when there should have been paragraphs and paragraph analysis on solely the fact that she's providing a statement against interest, right? You completely ignore that. But that conclusion is, I think, completely devoid, as we've talked about with Sally, very artfully put, willful blindness. Willful blindness to everything that had just come out before, how much it aligned with other testimony, that she's a state's witness, that it was his sister, all of it. So yeah, it truly really sticks out because there's clearly something else going on, and it's not justice or seeking to actually evaluate this guilty verdict. It really just seems to support the underlying conviction.
You know, you said so many things there that are powerful and that resonate with me. One is that I'm going to go back and find this, but I recall that the state in the direct exam, like you said, made it vague. Like when she said, "Oh, Smokey committed this. Chester was friends with Smokey, and Smokey did the murder with friends," leaving the impression. And I think this was improper, leaving the impression when they knew that she's not including Chester amongst the friends. And I had to bring that out in my exam. But my point is this: like you said, the state, I remember at the time, Sally, you, I, and Celeste in court were flabbergasted that they called her. And we're sitting there like, oh my God. Like, I think we felt like we're going to win just because of this. Because my attitude was, the state's calling a witness and vouching for her credibility. You have a burden. You can't call a witness to testify to something that you believe is not true. Clearly, they were vouching for her credibility because they thought, I think erroneously, that her story was different enough from Roy Tyson, which, as you say, I don't think it was. But putting that aside, why? I mean, my argument would be, okay, just take all our evidence, put it to the side for now. Don't we win because of the state's own witness? I don't have to put on any evidence. The state just did it for me. The state just called the golden witness, who they're vouching for her credibility. So how is that enough? And how does that just get dismissed? I mean, Sally, what am I missing here?
Right. I mean, I think we've said this before, but Alice Bohm should have been the whole case. It should have been that right there. And, you know, I'm not a conspiracy theorist. I really am not. But why did they call her? I mean, and why did they elicit that very misleading testimony about the friends? I mean, I think they thought that the judge could hang his hat on that if we didn't call them on it.
Yeah, and you know, and Johanne, just explain to people, her story wasn't perfect with Roy Tyson, doesn't need to be perfect with Roy Tyson, but highlight the similarities that did exist.
Totally. There was, actually, I believe it was very artfully put within one of our various briefs that we had, actually. Oh, do you actually mind if I read this section off? I think it perfectly encapsulates.
Yeah, please.
So,
Sally will get credit for this.
Exactly. Mr. Tyson's testimony provides significant corroboration of Ms. Bohm's equally illuminating testimony concerning her brother Smokey's involvement in the murders. Smokey told both of these newly discovered witnesses that he was hired to orchestrate the murders and was paid a significant sum of money for his efforts. He told both newly discovered witnesses that the murders were planned at the behest of the victim's husband. He told both newly discovered witnesses that multiple offenders were used in the attacks. However, Mr. Tyson's testimony adds additional detail to the confession Smokey made to his sister. These additional details are also completely consistent with the original trial evidence and further corroborated by the testimony of other newly discovered witnesses. So, it's obviously the key fundamental metrics and elements of Ms. Bohm's testimony directly align with the key fundamental elements of Mr. Tyson's testimony. Totally agree.
And in the judge's opinion, what's it like? You said it's a few sentences, kind of dismissing her on this point.
Yeah, he ultimately ends up saying her version of what occurred is significantly different than the story Rona told Tyson. That's it. End. No,
it's the core stories are spot on.
Exactly.
My brother told me husbands hired him to kill the women, and the Chicago Mafia is involved. It's unbelievable.
It really is.
When I go back, everybody knows I I've lived with this case for 10 years. I have talked about it. I've spent thousands of hours talking about it. And right now, in this moment, I still get as passionate as I've ever been, like as if I'm hearing it for the first time. Because, you kind of forget sometimes. And what really struck me today when I was getting ready to do this podcast with the two of you, we're talking about 3 discrete issues here. What struck me was how many we have. I was going through thinking about what I might want to talk about. And I thought, well, we've talked a lot about the hair. We've talked a lot about the DNA. We've talked a lot about the genetic genealogy. We've talked a lot about the missing finger. We've talked a lot about the fact that they got fractured skulls. We talked a lot about the twine didn't match. My God, we could do 10 episodes like this where we all picked an issue. We could do a 10-part series and have 30 strong issues. It just blows me away. Before I get into Randy Reynolds, is there anything else you want to say about Alice Bohm? Or were you able to say everything you needed to?
I think I largely said everything I needed to. Again, it's also one that would obviously take a much larger, conversation and deeper dive. But it's also just the court's complete ignoring of just the law. I truly just really astounds me, because the first time I hear that testimony, when I first read through the case material, I was like, oh, wow, that's a great statement against interest. That was one of my very first initial thoughts. And then to see that the court just doesn't even engage on that basis or in that analysis whatsoever, it just makes no sense to me.
Well, and to piggyback off of what you're saying, Johanne, and even more egregiously, I want to make it clear to the audience, the rules of evidence don't apply to post-conviction proceedings by statute. So you don't even need to talk about statements against interest because you don't consider the rules of evidence. The whole point is whether you get to a trial at which that stuff would be litigated. A new trial, that's where those things would be discussed. You do motions to eliminate, you do all of the evidentiary stuff at the new trial that you get from this stage. So that just, I'm off my high horse now, but that part is just really egregious.
Well, I mean, and to say that it wouldn't lead to a different result is nonsense. Let's put on the old evidence with what we know now. It's so weak, and it's such a weak case. And then we're going to bring in Alice Bohm to talk about her brother who told her he was involved in the murders and everything she said. You don't think that's reasonable doubt? Are you kidding me? Are you kidding me? Oh my God! It would be like there when she would be testifying, there you could hear a pin drop in a courtroom with a jury. Like they would be riveted. Oh my gosh. Let's go to Randy Reynolds. So I'll finish this out. It's kind of dovetailing on Sally's issue. We'll take a little deeper dive here, but it ties into the Dummett pattern. Randy Reynolds was a guy. He's now, at the time he gave us a declaration, he was 67 years old. In 1982, he was 24. His then wife, who's now deceased, worked with Dummett at the LaSalle County Sheriff's Office. So Randy, as a 24-year-old, husband of his wife Tina, attended this Dummett this retirement party, and they were talking about Dummett's so-called accolades in his career. And at that time, Randy was basically in the proximity of Dummett and a couple other people. And Dummett says, yeah, Chester Weger was innocent, but I got the son of a bitch to confess. Okay. So I find out about Randy Reynolds through a friend of mine who is local to the community and knows a lot of people. I went out and met with Randy in person. I prepared a written declaration for him to sign. There were a couple blanks I left open because I couldn't remember what his answers were about his age, the year of the party, where the retirement party took place. He wrote in Cooley's banquet hall, here's his declaration. Okay. I then went to newspapers.com, found articles about Dummett's retirement party that said, guess where it's at? Cooley's banquet hall, spot on. So I submit this declaration to supplement our post-conviction petition. So now I want to talk about Will County's response. And I'm going to talk about an email chain. And after the case was over, I did a FOIA request to Will County State's Attorney's Office for a certain time period about emails that mentioned Andy Hale. They fought me on this and claimed that it was all privileged. And I appealed that to, the administrative body that governs Freedom of Information Act requests. And that body ruled, no, this isn't all privileged. You can redact certain things, but most of this has to be produced because the administrative body did an in-camera review. So then I email Will County and say, okay, when am I going to get the documents? They ignore me. I email them and, a week later, when am I going to get the documents? They ignore me. They literally don't say anything. Okay, nothing. I have to file a lawsuit. I had to hire a law firm to bring a FOIA lawsuit that we settled, whereby Will County produced these documents to me. And I want to just show you, there's an email, they produced this, where I send an email to Will County here, and I say, June 20th, 2024, attached is a copy of the declaration of Randy Reynolds. We intend to file a motion to supplement our PC petition with Mr. Reynolds' declaration. Please let us know as soon as possible if you have an objection to such a motion. Okay? That person I sent it to, state's attorney, she forwards it to another person, state's attorney at Will County, who, and the woman I sent it to sends it with the heading, this is that declaration that Hale sent on Uyghur period. Really? Question mark? That's the response. Really? And then the other state's attorney gets it and writes back with Randy Reynolds' contact information and says, if it even matters, period, I agree, it is total nonsense. Let's pause there. Let's just pause there. I've got so many emotions about that. I mean, one is anger. I have been working my ass off on this case for years. And I find a powerful, credible witness who's got powerful, credible testimony. And the one state's attorney forwards it to another and says, really? And the other one says, total nonsense. This is what I have been dealing with the past several years. I'll let readers judge whether this was a search for the truth or not. People can draw their own conclusions from that. I was flabbergasted when I saw these emails produced to me. I just got this like a month ago. I could not believe the reaction was this really, and this is total nonsense, Randy Reynolds. So what happens is Will County then goes out and interviews him. I've got the written report and I've got the audio of that. And they interview Randy Reynolds at his house. And let me stop right there and tell you, I've been practicing law for 40 plus years. I have met and examined, cross-examined hundreds and hundreds and hundreds of witnesses in my 40-year career. I've been around the block. I feel like I'm a pretty good judge of witnesses' character and credibility. Let me tell you something. Randy Reynolds, if he was sitting here on this podcast, is such a honest, credible person the way he tells this story. He tells it matter of fact about what he heard. He just simply recounts what he heard. And if he were to tell it to you, there would be no doubt in your mind it was true. So Randy Reynolds is called as a witness at our third stage hearing, and I've got the transcript of that testimony. And I call him, he's 68 years old now. His wife's name was Tina. He says he's at the retirement party. He says, I'm reading from this, 1982, Cooley's Banquet Hall in Ottawa. He said there's 3 or 4 people around him. He knew one of the guys' names who was around him. He said, a guy named Charlie Smith. So he remembers him, Dummett, this guy Charlie Smith. And this is the part he says. He says, Chester Uyghur was innocent, but I got the son of a bitch to admit to it. And then he says, I said, what did you think when you heard that? He testified, I was really kind of devastated. He's 24 years old. And then he says he asked his wife about it when he got home. He said to her, like, what's up with that? And she said, oh, that's Billy being Billy Dummett. See, that's the way people know him, like Louis Getch. Bad Billy Dummett. And, you know, the cross-examination is really nothing. It's basically, they ask Randy, you know, who are the people? He said, I remember Walter Smith. They asked him if he reported it, okay? And he said no. He said, you know, this was his line. He says, you know, now that I knew what was going on. I mean, I was 24 years old back then. It didn't matter to me. The Starved Rock murders really didn't matter to me. So they're kind of hanging their hat on, oh, well, you know, you didn't say it you didn't go report it to the state's attorney's office. He testifies in court very powerfully, honestly, incredibly. Then we do post-hearing briefs. Will County doesn't have too much to say about Randy Reynolds. They say, we're not saying the statement is not serious if it was said, but for whatever reason, Mr. Reynolds thought it was so serious, he only brings it up to his wife, and he sits on it for 40 years. Again, I don't think that's powerful. This kid's 24 years old. He's going to go, what, report this to the state's attorney's office? And then the state argues in their brief, this is the oral argument, give the statement the same way Mr. Reynolds gave it for 40 years. None. Okay? That's how they argue that. And then the judge, and this is the part that really gets me the most, the way the judge handled this. So this is it starts on page 15 of the judge's, this is the same order that Sally and Johanne referred to in these other issues. This is the judge's June 18th, 2025, 30-page order denying our petition. So Randy Reynolds. This really, really got me. This is one of the things the judge said. The court had the opportunity to observe the demeanor of Reynolds while he testified in his manner of speaking. His answers on direct examination were more concise and confident about general and broad statements, but when questioned on cross-examination about the details, his manner of answering questions changed and he was less clear. Bullshit, okay? Bullshit. Randy Reynolds was no different on cross than he was on direct. That is just, in my opinion, a manufactured way to try to attack the credibility of a witness, to say, oh, well, I heard them testify, and to make up something like he was different on cross than he was on direct. No, not a chance. I've seen that before. Not a chance. There wasn't any, not a scintilla of evidence of that here. So I felt the judge was frankly fabricating that. And then the judge says, this is even more shocking. The judge says, the court accepts that Reynolds attended the party, but the court finds that the surprisingly detailed comment about what Dummett said, namely that Chester Weger was innocent, and I got him to admit it, is not believable. Not believable. So he's saying Randy Reynolds is making this up. It is an outrage. It is an outrage for the court to say that. And the court says, especially since he could remember a few details about who was present for the statement, he admitted that the Starved Rock murders did not mean much to him. And 40 years later, as he decided to say anything about it. I mean, not believable? It's incredible to me. And again, I wish, because I've spent time with Randy Reynolds, that's unbelievable. It's just unbelievable. And then the court talks here about the part about the airplane and getting two people to commit perjury that Sally talked about. This is so outrageous to me. And it's in the grand scheme of things, it's probably issue number 20. I mean, we probably got 20 bigger ones than this. but this one alone is still pretty darn big. Sally, what do you make of all that?
Well, one thing I wanted to highlight, in addition to what you just highlighted, and this is a little bit earlier, where the court is discussing Randy Reynolds' testimony. He says, it was established on cross-examination that prior to June 10th, Reynolds spoke to a family member who was aware of the defendant's case, liked to investigate it, and was excited to be, quote, helping Mr. Hale. She arranged for Reynolds to meet defense counsel, and she subsequently advised him that Defendant's Exhibit 16, that's the declaration, was at her house and ready to be signed after he filled in some information. So then he moves on from that, but you can tell by the way that the court is articulating that, Andy, he's accusing you of having concocted the statement that you're the one that made it up, according to the court in this paragraph. And that to me is, there's no reason to put this in if he's not making that implication against you, which is obviously completely unfounded, ridiculous, and just puts the tenor of the court's treatment of all of our witnesses had that feel to it. It was really astounding. I don't know how else to say it, but it's not grounded in reality. It is not reality-based observations. Of course, it's a post-conviction case. We have no ability to call these witnesses into court unless they want to be helpful. You know, they were there. What do they get out of it?
Yeah.
There's no fame in this business, you know?
Yeah.
So anyway, that just really made me.
No, and I'm glad you pointed that out because, you're right. And the implication that I just kind of wrote this and fabricated something for him to sign. There's a woman named Dina Herkert who lived locally and attended all the court hearings. And I think it was her aunt, was good friends with Randy Reynolds. Put me in touch with Randy Reynolds, knew about Randy Reynolds, and I went out and I met with Randy Reynolds. And he told me all these things in a very matter-of-fact way. Randy Reynolds is not saying anything more than what he heard. Randy Reynolds is not putting his finger on the scale. Randy Reynolds is just telling you, I was at the retirement party with my wife, and this is what Dummett said, and it shocked me. Okay? And then I took notes and I prepared this affidavit for him to sign, and I intentionally left blanks for the things I couldn't remember or he didn't say. And so again, yeah, to act like you'd only put that in there, like you say, Sally, if you basically want to give the implication that like this is on me, and I was the one who kind of got him to say this, but it's all BS. You know, it's just, I'm trying to think of the right word. It's frustrating is too little. Infuriating is probably more appropriate. Like it's infuriating, you know. And again, I wish the listeners could spend 15 minutes with Randy Reynolds in a room and he told everybody this story, because everybody would walk away with the same reaction I had, is that Randy Reynolds was absolutely there. He's not making this up, and it's powerful. It's powerful. Johanne, what are your thoughts on this?
I think kind of one thing that really does kind of stick out to me also is the court really hanging its hat on the fact that he didn't contact authorities at the time or take action at the time when he heard the statements. And I think you put it really well, right? Like he's 24 years old, but he's also hearing this at the retirement party of a LaSalle County sheriff officer. There are other cops around. Those are the authorities, you know? And again, this is 1960s where like the relationship that the public has with the police is very different. Like these people are considered in a different light than they may now in today's, you know, time and consciousness. And so to me, I feel like that's not a reasonable means to like attack his credibility, is that at the time, a 24-year-old man who overhears this terrible, devastating statement from a sheriff officer at a sheriff officer's retirement party with other officers and authorities. Where his
wife works.
Exactly, you know? Exactly. Who is he? You know, I don't know. I feel like that's a somewhat unrealistic ask of like, oh, you should have contacted authorities. These are in many, you know, ways, shapes, and forms, these are the authorities that he would have contacted. So they're the ones making these statements. I just think that that's a very odd characterization to me.
Well, and it is rich coming from Will County to put blame on Randy Reynolds for not going to authorities when you know who went to authorities time and time again, Andy Hale. And what did they do? They called him. What did they say in that email? You know,
really nonsense, total nonsense.
Yeah, I mean, what reaction was Randy Reynolds going to get? I mean, here you go. You've been litigating this for 10 years.
Yeah.
Being so dismissive of anybody that puts anything in front of your face, and now you're saying that your witness is not credible because they didn't try to get you to do what you've never been willing to do. It's crazy.
And then to go right off of that as well is like, what does happen when a witness does go to the to the authorities or is literally brought by the state as a witness? The court still finds the testimony not credible, even if it's the one being brought by the quote unquote authorities that they mentioned that other witness should have went to. So it's like it's a lose-lose situation. It just doesn't track.
And when I see these emails when it's like, really, and then the other state's attorney's like, I agree, it's total nonsense. You know, I first said this was, so it makes me mad, but it's also incredibly sad. Mm-hmm. It's sad to me. Like, there's a part of me that's like, it's just really, really sad that you could be wrongfully convicted, you could be innocent. Your lawyer could present evidence that he thinks is supporting your case. It's submitted to the body that is supposed to do a good faith investigation of the evidence and take it seriously and assess it. To think it could be met with that kind of a response, which, by the way, that those emails are, that's happening the day after I submitted the affidavit to them. They don't interview Randy Reynolds until July 17th. This is going on in June. So it's not like they've even met him yet. You don't even have a basis. First of all, there wasn't a basis to think Randy Reynolds was nonsense, but you haven't even talked to this guy. You don't know anything about this. And you're already concluding it's total nonsense, I think is pretty telling. Oh my gosh, I've had so many sighs on this podcast, so many deep sighs. Well, I think we've covered enough for now. We could go another hour on this. I think what we might want to do down the road is maybe we just go through this Judge Jan's opinion page by page down the road and just because when you just see what we just did just now, you see of the willful blindness on Dummett. You see the way it was handled about Alice Bohm. You see the way it was handled about Randy Reynolds. I mean, and then I think we might need to do that, because then when you see all of this together, the wrong legal standards, right, and these comments, then you have to just wonder what is going on here. At what point, after how many mistakes does it fall out of the category of there was like an innocent mistake here, and somehow got it wrong, I guess I'll leave it at that. Any parting words, Sally?
No, I mean, every time I look at this opinion, I'm reminded just how bad it is. And somehow I forget in between. So then I get outraged, but I'm glad that we all share that emotion. So good to talk to you guys.
Johanne, any other parting thoughts?
Just thank you for inviting me on. Obviously, always great talking with you guys and talking through the case. And as I've mentioned to you both in person before, I always find myself kind of on this case and all other cases that we kind of handle just ranting at times about kind of what I believe to be justice that occurred. So it's always great to have an environment where you can, in fact, rant with others. So thank you.
And I want to say one last thing. Sally, you clerk for an appellate court judge, and then you worked at the Office of the Appellate Defender, correct?
Yes.
How many appeals do you say you were involved with in some way?
Ooh, 50, 50, maybe more.
That you were personally involved with?
Yeah.
Yeah, like in terms of researching and looking at. And so based on your appellate experience, and most people, by the way, okay, I mean, Mine's probably a handful. You know, I mean, like 50 is a ton. 50 is like this is an appellate expert who knows appeals. I would never put myself in that category. Based on your appellate experience, what was the strength or weakness of the judge's opinion here denying our post-conviction petition? And what would you kind of like be your ballpark feelings of our chances of success on an appeal? And I know it's hard to say that.
Oh, it is, because appeals are very hard. It's for a reason, you know, you don't overturn every decision, right? This particular opinion, to me, is egregious in and of itself. But as I mentioned earlier, we would have also appealed the constitutional rulings. So there would have been so many bases to reverse at this stage and earlier. To me, there's no doubt in my mind that the misapplication of the legal standard and the evidentiary standards, and then also just the mischaracterization of the trial record, I would say 97% chance of reversal.
Unbelievable.
We're not supposed to tell our clients numbers, but I'll give the audience a number. 97%.
And one last thing, you can tell here, I can't yet let this, like this, I don't want to quite end this podcast. I got to keep going here a little bit. What's incredibly sad to me, and I'll never forget this moment, you probably remember this. So the judge read that 30-page opinion in open court. He then very abruptly said, okay, what did he say? Like, you know, like everyone's dismissed. Like He kind of abruptly got off the bench. We had an hour and a half of him reading it, so it was a slow burn. We knew we were going to lose, right? Even though at the end, I think we thought maybe there's a slight chance we could win on the DNA, but no, not really. So then we gathered our emotions. We walked into the foyer of the courthouse. I don't know if you remember this. And there were reporters there waiting and said, "Are you going to appeal to me?" And I said, "Yeah, we're going to appeal." But I knew at that point, and everybody knew at that point, that Chester was dying. And I knew at that point that obviously we're never going to be able to pursue an appeal, because Chester was in days of death and Chester died days later. And so I just remember being in that courtroom and feel like in the hallway, and it was just incredibly sad. I felt so bad for Chester and his family in that moment, knowing that if he could have hung on longer, we could have gotten there with the appeal, and that we weren't going to have that chance was just incredibly, incredibly sad. So, okay. On that note, let's end with this. Everybody out there, please, 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 check out the link below. Sign our petition supporting our change.org petition, supporting our petition for posthumous clemency. We got a hearing in October. We're going to be back on this podcast before then. Thank you to everybody for their support over the years. It's been so appreciated. Stay tuned. More to come.